Hey everyone, welcome to week 2 of Healthcare Law, Ethics, and Compliance. Hopefully everyone did okay with week 1, got all of their assignments done. Today we're going to talk about the court systems and legal procedures. So as we all know, the purpose of going to court is to resolve a dispute because especially nowadays, filing lawsuits is how people deal with disputes, right? No matter how big or small. Both federal and state court systems use a multi-tier structure, trial courts, intermediate courts of appeal, and a Supreme Court. So the difference is what types of cases can be brought before each one. And we're going to talk about that all in a second. So jurisdiction is the authority by which courts and judicial officers can hear and make a decision about a case. So it encompasses authority over, 1, the parties involved. This is called personal jurisdiction. And 2, the question at issue, which is called subject matter jurisdiction. Now, in the federal courts, subject matter jurisdiction is more limited than in state courts, as you can see by the smaller circle. Some lawsuits can be brought in either state or federal court. As a general rule, cases may be brought to federal court if they meet the requirements of either federal question jurisdiction or diversity jurisdiction. So federal question jurisdiction refers to cases that involve a U.S. constitutional principle, treaty, federal statute, or federal rule or regulation. It also involves cases that would typically be considered a state case, but they happen on federal land, like a military base or a national park. Cases can also be brought to federal court under the theory of diversity jurisdiction. So if the case involves parties who are citizens to different states and the amount in controversy is over $75,000. So both of these things do have to be present to meet the diversity jurisdiction requirements. So in these cases, the federal court will apply the substantive law of whichever state the federal court is physically located in. Okay, state courts, on the other hand, usually maintain general jurisdiction, meaning the subject matter is not limited. But the state courts can be subdivided into more specialized courts dealing with limited subjects, such as probate court, juvenile court, and small claims courts. Okay, sometimes jurisdiction is concurrent between the federal and state courts. So when this exists, the party bringing the lawsuit can choose between the two court systems. So for example, like in a medical malpractice case where the citizen of one state, the patient, and a citizen of a second state, which is like the doctor, this case can be brought to either federal court using the diversity jurisdiction if the case is asking for over $75,000, or the state court. It usually just depends on how soon of a trial date they can get and if certain procedural rules would benefit the plaintiff going to a federal court versus state or vice versa. In addition to subject matter jurisdiction, courts must have personal jurisdiction in order to issue a valid judgment. So this refers to the court having authority over the person as opposed to the person's property, which sounds a little strange. I know the court, having authority over the person, but when a plaintiff files a lawsuit, they're voluntarily submitting to the personal jurisdiction of the court. Personal jurisdiction of the defendant mainly depends on if they were properly served with the summons and complaint. Okay, as I said, both federal and state courts operate within a multi-tier structure, as you can see here. So starting at the bottom, we have the inferior courts. So municipal courts have very limited jurisdiction. They deal with mostly like misdemeanors or petty offenses committed in their own city. And then we have trial courts, which are called district courts in the federal system, then intermediate courts of appeal, and then the highest courts, Supreme Court. So cases have to travel up that way, okay? Trial courts conduct trials in civil and criminal matters, and then also supervise the discovery process that happens before the trial, okay? The losing party in the trial must decide if they want to appeal. If they do, the lawsuit moves to the intermediate appellate court. Appellate courts are very different from trial courts. There's not another trial, so there's no testimony of witnesses, no evidence presented. They basically just look at the record of events that happened during the trial and see if any errors occurred that would merit a reversal of the decision. Each side does give a written brief and then an oral argument. Okay. Appellate courts in the state system are usually just the state name followed by Court of Appeals. So Louisiana Court of Appeals. The federal appellate courts are divided by geographic region and are referred to as circuit courts of appeal. Then we have the highest level of court, which is the Supreme Court. Each state has its own Supreme Court, and the federal government has a court of last resort called the Supreme Court. So that's what you usually think of when you think of a Supreme Court, the U.S. Supreme Court. There's one exception, which is in New York. The court of last resort there is called the Court of Appeals, whereas the trial court is termed the Supreme Court. So it's backwards. So other than in New York State, these Supreme Courts hear appeals from the intermediate appellate courts below them, right? Very rarely can you bring a case to the U.S. Supreme Court without first having been heard in a trial or intermediate appellate court. The U.S. Supreme Court hears appeals from all of the different federal circuit courts of appeal, okay, in the highest state courts, right? And these are cases that are involving the U.S. Constitution, federal statutes, treaties, rules, regulations. The U.S. Supreme Court decides which cases to hear by granting, granting a writ of certiorari. So thousands of cases apply for this writ every year, and the U.S. Supreme Court only grants about 150 of them, so a really small amount. Okay. Every court in America has court rules that pertain to things like statutory requirements, uniform procedures, just generally how proceedings are conducted. Most of the federal level rules are the same ones used by the state level. Okay, so being the highest court, the U.S. Supreme Court created all of the rules for the federal system. The most well-known federal rules are the rules of civil procedure for civil cases, the rules of criminal procedure for criminal cases, and the rules of evidence for the admission or exclusion of evidence, and that's used in both civil and criminal cases. There are also special rules that govern paper-based and electronic health records. Okay, the civil procedure rules and the evidence rules are the most important to health information management professionals because they govern the admissibility of the health record into evidence. So the civil procedure rules, they kind of prescribe like how the trial will proceed, what the discovery process is like, the subpoena process, okay? The evidence rules deal with privilege, testimony, hearsay, and authentication and identification. There are two tables in your textbook, table 2.3 and 2.4. I think they're on pages 27 and 28, that give the articles and the rules for these sets of rules. So if you can check that out if you want. It's kind of interesting, sort of. All right, let's see. The stages through which a lawsuit passes are referred to as the legal process. So you can see that here. We're going to go through each one of these. All right, first things first, the person who initiates the lawsuit is called the plaintiff. The person sued by the plaintiff is called the defendant. And other parties can be present. It just depends on the complexity of the lawsuit. But the first step of every lawsuit is the plaintiff filing a complaint, which is a written document that includes why the court has jurisdiction, what the plaintiff's claim is in like a short, just plain statement, and the demand for relief or damages that they feel they're entitled to. So how much money they're wanting. Okay, after filing the complaint with the court clerk, the plaintiff or his attorney will receive a summons from the clerk that has to be personally delivered to the defendant along with a copy of the complaint. Okay, this is called service of process, more commonly known as being served. I'm sure you've seen that in a movie or show before. Okay, after receiving the complaint and the summons, the defendant has to write a written response called an answer, where they can either deny or admit to the contents of the complaint. They can also make a counterclaim against the plaintiff, which was what happened in the, I mentioned last week, the Johnny Depp and Amber Heard case. So he had sued her for defamation, and then she countersued him for defamation. Okay. The defendant typically has 20 days to file their answer. And if they don't, the court can decide on the case without, ever hearing anything from them, and they can enter in a judgment. So hopefully this never happens to you. But if you are ever in this situation, it's in your best interest to file an answer. There's also a number of motions that the defendant can file to try to prevent the case from ever even going to trial. Okay, once the complaint and answer stage of the lawsuit is complete, the parties and their lawyers start the investigative process to get information or evidence for the lawsuit. So this is called discovery. It's one side getting information about the case from the other side, okay? Here are just some of the different types of discovery. So a deposition is a testimony under oath outside of the courtroom. Interrogatories are written questions answered under oath. The production of documents or things, this is just actually making copies of physical evidence. They can try to request like a physical or medical examination. Requests for admissions are written questions presented to one side to try to get them to admit to like a specific thing, a certain fact. Okay. Any information that is in electronic form, whether it's business records or the patient's electronic health record, the process is then called e-discovery. The federal rules of civil procedure govern all forms of discovery that take place, but in 2006, they did revise them to include electronically stored information, or ESI. So ESI would be like emails, web pages, word processing files, databases, all that stuff, hard drives, DVDs, etc. Okay. Because ESI is so unique, there are a lot of issues that are not typically seen when dealing with paper-based information, including all of the things listed here. So a larger number of relevant documents, documents saved in multiple places, dynamic quality, so the ability to change data, metadata, the fact that if something is removed from the system, it may not be understandable anymore, and that ESI can be recovered even if it's been deleted. Okay. Other things to consider is what format should ESI be produced in? Should it be a PDF or a Word document? What if it's a JPEG, which is essentially just like a photo of a document? That would make it a lot harder for the other side to search for things in it, right? Because you can't Control F to find a certain word or something like that. Will ESI production result in undue burden? Meaning, will it take the responding party way too much time or cost too much money to produce the information? Will the production of metadata cause detriment? Metadata is basically data about data. It's usually hidden information in computer files that tell us when the document was created, viewed, revised, and it could have, edits or notes or other private data. So if the responding party accidentally releases some metadata, it could hurt their case without them even knowing it. Now, in some situations, it would be appropriate to release the metadata. Like there have been malpractice cases where the metadata showed conflicting entries for the same items on the same day for patients, and the providers couldn't give a good explanation for it. So the court had to order the metadata be released to see, was the data altered and who did it. So health information professionals need to have a good understanding of the concept of metadata in the event of, receiving a request for an audit trail of EHR. An audit trail is a record or catalog showing the sequence of user activity of a computer system. Creating and reviewing audit trails are requirements of the security rule of HIPAA. Okay, let's see. Do computer operations need to change to preserve ESI so that it's not accidentally destroyed or accidentally altered, or even intentionally? Some businesses will routinely recycle backup tapes or override disks just as part of their operations. Will production of ESI waive privilege? If privileged information is accidentally released, an agreement between the parties or a court can specify that the privileged information has to remain confidential. Is modification or destruction of ESI considered spoliation? Will sanctions be imposed? So spoliation is wrongfully destroying or altering data or evidence, or failing to preserve the data for another's use as evidence. So basically the opposite of preservation. A big part of spoliation is finding out whether or not the party that destroyed the evidence did so on purpose. So that's very hard to prove. Okay, so we already talked about metadata, but every facility should have policies and procedures in place, either paper or electronic form, to, so you know how to handle all of that. Going back to preservation of information, there's something called a litigation hold. That means the party that possesses the data has to make certain efforts to prevent the routine destruction of ESI. An order of preservation is a court order requiring a party to preserve electronic and other evidence, regardless of the party's need to, if they routinely delete this information or, destroy stuff. Regardless of that, right? They need to preserve it. In the case listed here, Zulu Lake versus UBS Warburg LLC, a woman filed a discrimination lawsuit, and the defendant deleted certain incriminating emails, and then also did not preserve the backup tapes that contain the emails. And so in that case, the woman ended up winning almost $30 million in damages because the party failed to preserve that information. All right. A deposition is when one party subpoenas a witness to appear at a given time and place to testify under oath. The person answering the questions is called the deponent. It usually takes place outside of the courtroom, like in the lawyer's office, with both sides' lawyers being present, and a court reporter who will administer the oath and transcribes the testimony, like word for word. The main purpose of this is to uncover details about the case, right? And depositions are submitted as evidence at trial, in case, if the deponent is not able to attend or to contradict their testimony, right? So if they say one thing during the deposition and then another thing on the stand, they can pull up and play that video, that recording right then and there, and kind of use that against them. Written interrogatories are a much less expensive way to get details about a case. So one side will send written questions about the case to the other party or a witness, and then that party will answer them in writing, sign a sworn statement that what they wrote is true. The party can object to answering the questions and give a reason for why they object, but it has to be in writing and it has to be within 30 days. Production of documents and things is another discovery device that lets one side look at and copy documents and things that are not already in that side's like physical possession. So in this instance, a written request is served to the other side, specifically stating, the items and the categories, along with, like a reasonable deadline to get a copy of that stuff. So the party that receives the request can object, but again, it has to be in writing and usually within 30 days. A request can include a subpoena duces tecum, which is just a more formal request to produce a record. Okay. When the physical or mental condition of the plaintiff is at issue, in that case, the defendant can ask the court to order the plaintiff to have a physical or mental exam done by a physician. The request has to be, like supported by some sort of reasoning that, would require that. They can't just, well, I think she's crazy. We need a mental exam done on her. Okay. Now, a request for admission is similar to written interrogatories in that, one side's asking the other a series of questions. How they're different is that the questions aren't designed to gather information, but so that the other side will admit to certain facts. Okay, very small difference. The party has to respond within 30 days, or else the subject matter of the request will be deemed admitted. Okay. Many trial courts have local rules that require the parties to meet with the trial judge before the trial date is set to discuss the statutes the status, and issues of the case. So at this pretrial conference, the trial judge will rule on any outstanding motions there are, if there's any like discovery disputes, help the parties like further define the issues, and then like discuss the possibility of a settlement. So if the case isn't settled at that time, then the judge will set the court date. So now we get to the trial, which is where the court hears about all the issues between the parties. Certain cases are not entitled to jury trials, like divorces or adoption proceedings. So for those, the trial judge will make the decision. When the case is tried before a jury, the jury will decide the disputed facts in the case. I'm not going to go into great detail about what happens in the trial. I think most people probably have a decent idea about, opening statements and presenting evidence from each side. But if you want to look more into it, your textbook has a section that's probably like a page and a half long, all about the trial. Okay, after the jury returns the verdict, the losing party can ask the trial judge to overturn the verdict by filing a motion for judgment, notwithstanding the jury's verdict. Okay, they can also seek a new trial by submitting a list of errors to the trial judge that the party believes caused them to lose. But whatever the trial court's decision on these post-trial motions is, they eventually will enter a judgment indicating who won and who lost in the case. After all the appeals are exhausted, the winning party can then collect their money. So this process is called satisfying the judgment. The most common ways to satisfy a judgment is to either obtain a writ of execution or an order of garnishment. So a writ of execution, which is the most common method in the federal court system, is a written document that orders like the sheriff or other local officials to take the property of the losing party and sell it to satisfy the judgment. In order of garnishment, the employer of the losing party is directed to pay, like take a certain percent of their wages and give it to the winning party. Now, alternate methods of dispute resolution are becoming more popular in the US because it's a lot cheaper and a lot less stressful to come to an agreement without going to trial. It takes a lot less time also. There's a table in your book that goes over the similarities and differences between these three methods, and it kind of makes it make probably more sense. But in general, mediation and arbitration both use a neutral third party to decide the case. The difference is the third party in arbitration is someone that's an expert in the subject of the lawsuit, whereas in mediation, they're not an expert. They're just a non-biased third party. Also, mediation is a voluntary process where both parties, come to an agreement. Whereas in arbitration, it's a mandatory process, and the arbitrator makes the decision. With negotiation and settlement, each side works with their attorneys without a third party to come to an agreement. So they just try to work it out together. Okay, that's it for this chapter. Let me know if you have any questions. Have a good week.